Shall we begin?
Hmm.
A very good evening, everyone, and welcome to the second edition of 15-day online capacity building program, FDP on AI, technology, and law, jointly organized by Faculty of Law, Integral University, Lucknow, and Law Teachers India. I am Priyanshu Saxena, Assistant Professor at Mewar Law Institute, and I'll be your moderator for today's session. So before we begin, please keep your microphones muted and use the chat function for any questions during the presentation. Well, today's topic is forensic evidences and its analysis. And we are honored to introduce Dr. Keshav Kumar, retired IPS, former DGP Gujarat Police, and former Director ACB CBI, who brings over 35 years of distinguished service in criminal investigation and forensic science. Dr. Kumar served as Joint Director of CBI in Delhi and Mumbai, and he was the first Joint Director of CBI's Interpol wing, revolutionizing forensic applications in crime detections. His groundbreaking work includes securing convictions for 63 accused through DNA evidence and leading the landmark Gear Lines poaching case that resulted in 38 convictions, one of the world's largest wildlife crime convictions. Recipients of President's Police Medal and FBI Director's Commendation, Dr. Kumar now dedicates his expertise to academia at National Forensic Science University and holds a recent PhD in forensic psychology. His pioneering research in forensic evidence analysis and wildlife crime investigation makes him the perfect expert to guide us through today's crucial topic. Please join me in welcoming Dr. Keshav Kumar, sir, to share his invaluable insights on forensic evidence and its analysis in context of AI and technology in law. Thank you so much, sir, for doing this for us, and most welcome, sir. The floor is yours.
Thank you so much, Priyanshu, for giving a very glorious introduction. And I'm very grateful to Dr. Kalpesh, because of whom I keep getting invitations for addressing on some questions or the other. And I'm happy because, at the age of 65, when Dr. Kalpesh gives me a topic, I have to really put my heart and soul into it and prepare the presentation accordingly. And to tell you, Priyanshu and Kalpesh, that this presentation that I have made, that is a bespoke presentation for this occasion, and I have drawn heavily from my experience and whatever investigation that I have done, and I have culled into this presentation. So now I would thank you once again for inviting me. And now we can begin. Next slide, please. Kindly help me with the slides. So today I have to speak on forensic evidence and its analysis. So I will be just giving the plan of presentation. Next, please. So I would like to, divide my plan of presentation. What are the things that I would be discussing here? I have about an hour with me. So initially the introduction part, then the Locard's principle of exchange. I'm sure, I don't know how many of you have heard about Locard's principle of exchange, but I think that before understanding investigation and also forensics, it's very, very pertinent to know what exactly is Locard's principle of exchange. Although it's a very vast topic, but I would like to give you a flavor. In 1 hour, I cannot give you much more information, but I will try to give you a flavor of it and the various topics that I would be covering. So I will be talking about the types of forensic evidences. Then I would be talking most, from the legal point of view, what is most important is the importance of chain of custody. And I feel for investigation, chain of custody is very, very important. Then what are the key forensic disciplines? I would be dwelling very heavily on DNA evidences. Next, I would be talking about the fingerprint analysis, then be going to the digital evidences, and then the role of lawyers in forensic evidence deposition. What are the limitations and challenges? And finally, the conclusion. I have taken a number of case studies for giving this presentation. And I begin from the legal perspective. I begin the presentation with the point that you're innocent until proven guilty. So you have to prove that the person is guilty. Till I am innocent, till you prove me guilty. So this is the journey for all of us, and how in this journey forensics is going to help us. How the depositions will take place, what the prosecution will ask, what the defense will be defending the thing, and how the prosecutors and how the honorable judges would be appreciating the evidences put forth by the investigating officer. Next. So basically, the forensic science is nothing but it bridges the gap between science and law. So forensics is nothing but application of the science for the purposes of criminal investigation and criminal litigation. Next. So the broadly it provides us with the objective, and it also gives us reliable information for legal proceedings with the forensics in background. Next. Why is it essential? It is essential because it strengthens the prosecution and also the defense strategies. It gives a very broad view of to the honorable judges to appreciate the evidences put forth from the prosecution point of view and put forth from the defense point of view. Next. Now, this lookout principle of exchange, which is a fundamental concept in forensic science, but it has been my experience that very many of us wouldn't really be knowing what exactly is lookout principle of exchange. And wherever I have been teaching or training forensics, this is my first slide that I must teach on the lookout principle of exchange. So I would request all the people who are listening to this presentation that they should make it a point to go through the lookout specifics in great detail. I would be giving just a flavor, and I personally feel that lookout specific exchange is the first step towards investigation. If we are able to master the Lacoste principle of exchange and its application in investigations, I think half the battle is won. And more often than not, most of us are not aware of the nitty gritty of the Lacoste principle of exchange. So let us see what exactly is Lacoste principle of exchange and what are the fundamental principles of it. So it was proposed by Dr. Edmund Locard, 1876 to 1966, a pioneer in forensic science, and he is also known as Sherlock Holmes of Lyon. Lyon is the headquarters for the Interpol. And when I was in the CBI, I used to quite frequently visit Lyon and have fond memories of Lyon and Edmond Locard with this information. And this was formulated the principles in early 20th century. Next. Now, what exactly is the Lucas principle of exchange? The principle states that whenever two objects come into contact, so the premise is two objects coming in contact, then there is a mutual exchange of material. And what is this? So every contact leaves a trace. Like we all are sitting right now and on the net. You are sitting on the chair. We are also sitting on the chair. So we are leaving our traces on the chair, like each and every one of you is leaving your DNA on the place where you are sitting. So the place where you're sitting, that is giving you something, and you're giving something to the chair. So this exchange, this is the primary step of investigation. That whenever two people come in contact, the perpetrator, the victim, then there is exchange of information, and those are the things that make or mar the investigation. If we are able to pick up what exchange took place and it was given by whom and received by whom, then the fundamentals of investigation will be very, very easy. So I can tell you with my experience that this is a very elementary thing, but but it is rarely being followed, and I feel that this could be the problem of the conviction rates here. If I tell you the present conviction rate in all the cases is roughly about 54%, and in serious crime it is about 34%. And I squarely blame the investigating officers who have not been able to put the required means of exchange in in a very professional way. As a result of that, the connection between the crime, the perpetrator, and the victim is not being established. And as a result of that, acquittals are taking place. So, with my 35 years of experience in investigation, I feel that whosoever starts the investigation, and also from the point of view of the prosecutors, this principle is very, very important, and we must understand it thoroughly well. So, at the scene of crime, the criminal always leaving something at the scene of crime. Suppose, some person comes for, as a burglar in the room. So he is leaving his fingerprints. Maybe suppose he's coming, he's going out of the room, and finally he gets some bruise somewhere, and his blood falls on that, on the window. So he is leaving his blood on the windows. So this is the exchange of information. The criminal is leaving his blood. He is leaving his fingerprints. Now it is upon the police investigator to pick up that blood and pick up that fingerprint to prove that yes, this person indeed had entered this room. So, at every point of time, there is exchange of information. So, what do they do? They also take something away with them. Now, what are these trace evidences? Like, fingerprint, the blood, maybe he has sneezed, so there could be some nasal discharge on the window, on all the places. Maybe, he has, it was a summer evening, and, there was too much of perspiration. So he just wiped out his perspiration and he threw it on the ground. So he's leaving all his body fluids. Now, these are all trace evidences. Among these trace evidences, there are also microscopic things like DNA. You can't see it with your eyes, but we all are leaving our DNA wherever we are sitting at the moment, and all these things can be scientifically detectable. Now, this is where the forensic science plays a major role. Like to give you an example, recently there is a new invention called MVAC. Now, this MVAC system, what it does, it can lift DNA traces from the fibers also, from the clothes. Like in the cases of sexual assault cases, the linen plays a major part. But how do you find a DNA there? So there has been a improvement in the machinery, and we are getting now that is called MVAC. What it does, it sucks from the fiber, and then they develop DNA from there. So it is all scientifically dictated, however microscopic it may be. Next. So, what are the types of evidences that can possibly be traded? Now, these are some of the evidences, biological evidences. I have divided into a number of segments of evidences, types of evidences. Among the biological evidences, there could be hair, there could be skin cells, there could be blood, could be saliva. I would be focusing more on the crime against women and children because in such cases, the biological evidences play a major role. Like in POXO cases, like in rape cases, these trace evidences are of very, very high value. And the art of extracting those things from the scene of crime, whatever, maybe the knife, maybe the fingernails, all these things are leading some of the trace evidences. So these are some of the prominent ones. It's not a full-fledged list, but it is the prominent one. Next, next, please. Then we have the physical evidences. Now, what could be the physical evidences? Like fibers, the glass, the fragments, or the paint chips. Now, to give an example, like you're sitting in the chair. So, the fibers of your clothes are getting entangled with the fibers of the chair. So, there is an exchange of information of fibers. Now, in cases in which there are accident cases, there could possibly be exchange of glasses, the fragments of the glasses, and the paint chips. Like if a car is of blue color, it collides with a car of a red color. So there will be exchange of paint. So this the paint analysis will be done, and that will be the thing that the two objects are exchanging something with them, and that has the forensic evidence. Next, then we have chemical like gunshot residue. So with this gunshot residue, it is basically a concept of ballistics. Like when you fire when you fire a bullet from a weapon, so there are very many gases. They are emanated from the backside of the weapon. So they get entangled with your clothes and also on your fingers. So that GSR, it is called GSR, gunshot residue. So it is picked up and chemically analyzed to prove that yes, the chemical inside the bullet and the chemicals found on the clothes and on the on the hands are the same ones. That is how we connect that yes, this particular weapon was fired by this person because the remnants, the gunshot residue was found on his fingers and on his clothes. So this is again an exchange. Again, I would like to always mention about the exchange of information when two things come in contact, like toxins. Then the toxins are also the same thing, same variety. Next, now, let's come to the digital area. Now, I personally feel in the digital world, in the modern context, digital world is such a world that whenever you are pressing any key on a computer, on a laptop, or on a mobile phone, or wherever, for that matter, in a digital world. So we are leaving our digital fingerprints there. Now, this digital fingerprint is of vital importance. I would like to also stress here that after the BNSS Act, which has given number of things, the technological interfaces in the investigation. So, digital fingerprints are of vital importance in each and every investigation. Now, even in conventional investigation, suppose there is a murder case, there may have been some exchange of information between the two laptops on the mobile phone. So they are leaving the fingerprints there, and that is analyzed by the forensic expert. So in digital world also there is exchange of information. Not only exchange of information in terms of digital fingerprints, but also in terms of conventional. Like I'm using this laptop, so obviously this laptop will be having my fingerprints. So there is a convergence of conventional information and also the digital information here. Next. So applications in forensic investigation. Now I will be talking about, I will discuss about the various types of evidences. Now, what are the applications in forensic investigation? So what it does, it links suspects to victim or scenes of crime or the perpetrator. So, I try to see any crime into three quadrants. Number one, there would be a person who would be a victim. There would be a person who would be a perpetrator, and there would be a scene of crime, and all these things get coordinated. Now, how to coordinate all these things? If we are able to weave a thread between these three quadrants, the victim, the perpetrator, the scene of crime, and the physical evidences through forensics, then your job is done. Half of the battle is won. But unfortunately, again, the application of the locus mixture exchange is not very well understood by the investigating officers, and as a result of that, what happens, that weaving into the investigation, that chain of custody, that chain of command is lost, and as a result of that, the case goes in for acquittal. So these are the things that I would like to stress every time, that there is exchange of information when two things come in contact. So whenever you're investigating a case, whenever you are at maybe you're fighting a case, so this principle will be very very handy to you to understand the forensics application. Next. So it can also lead to reconstruction of the sequence of events. It can help you in reconstruction of evidence, like whatever physical evidence that you have found at the scene of crime, it will help you in reconstruction. It can also corroborate or disprove, like DNA. If the DNA is found, it can also lead to conviction. But at the same time, it can also lead to acquittal. Because if your DNA is not found there, then DNA is helping you for getting acquittal. But if your DNA is found there, then it helps you in getting a conviction. It can also corroborate and disprove what the witnesses are saying. Suppose a witness says, I never went to that room. I was somewhere, some alibi is given there. But in during the investigation, if we have scanned the scene of crime property, I'm sure if the person has gone into the room, he would have left his fingerprints there. So we can prove that. Good, yes, You are saying that you never went to that room, but your fingerprints are found in the room. The CCTV has captured your photograph there. So, this will help us in corroborating also of the witness statement and proving whether he is speaking true or lies. Next, then supporting circumstantial evidences. This can the application of forensics will be able to help you. Now let us see how what are some of the cases in which these things can possibly be felt. Next, like in hit and run cases, there has to be an exchange of information of paint and glass fragments whenever two objects collide with each other. So these are the remnants that can be found at the same, and that is how we are weaving it into the investigation. Next, then, sexual assault cases, the biological fluids. The biological fluid, the fibers, the hair, all these things are very, very important. In sexual assault cases, I personally feel one of the most important places where more evidences can be found, apart from the vital other evidences, it is also the fingernails. Because, there may be fight, so, there will be exchange of information. The perpetrator may have left his fingernails on the other body parts. And the victim also may have inflicted some injuries. And again, the fingernails will be having the evidences of each other. So this is how we can possibly link the victim and the perpetrator through the biological fluids. Next, burglary. Suppose the person enters the room and he leaves his fingerprints. He loses his tool marks there, and that tool mark can again be captured after the tools are found from the burglar. Then the tool matching can take place. Maybe that person has come, the soil, like the person has come into the room. Obviously, the room may be having some, if there is some soil there, or say it is a outdoor case. So he might have gone into the farm, then that farm soil would be clinging onto his boots. So if that examination is done, then we can prove that yes, the boots are containing the soil of that particular place. It means that person had gone there. So this is how, at each and every point there is some exchange. And the idea is to spot that exchange. Next. Then what are the limitations? Obviously, every thing has its limitation or the other. So all these trace evidences that I'm talking about, it is very difficult that it can be detected. But you have to be very lucky. Now, I was telling you the example of the new DNA machine that is called MVAC that extracts DNA from the fibers also. Earlier, what used to be done that the fluid body fluids from the cloth, they were scraped. There were chances that you couldn't possibly get all the eminence inside the fiber. But with this MVAC technology, what it does, it sucks each and everything from the clothes, and then that is analyzed for the thing. So earlier, when this MVAC was not there, there were some limitation that we were not able to get that thing. But with the coming of the MVAC, now we are able to get all these things. Next, then the problem would be that evidence may have been degraded, or it could also be destroyed. Suppose it is burnt, then it is very difficult to get that. So these are some of the limitations in extracting the trace evidences from the scene of crime. Next. Now, what are the limitations? The limitation is the collection and preservation challenges. Subsequently, in my presentation, I will be discussing very, very many live cases in which the collection part and the preservation challenges will be discussed from the cases, from the live cases, which have recently been given judgment by the Supreme Court Honorable, and they have been acquitted. Now, I have tried to understand that judgment, that from the point of a judicial point, okay, what was the contention of the prosecution, what was the contention of the defense, and how it was appreciated by the honorable judges. So once you have a hang of all these forensic evidences, then the counter arguments and the supportive arguments will be playing a major role in appreciation of evidence. And this collection and preservation challenges are very, very important, in especially in the DNA evidences, which I will be subsequently discussing through the live cases. Next. Then the possibility of contamination. Contamination is one of the most important issues, I can tell you, that can make or mar the investigation. Now, suppose, I will tell you, trying to give you a contamination part. Now, suppose, you are at the scene of crime. and you're trying to pick up evidences. You found some blood, you found some stains, and you started picking up those. Now, during that time, you were having cough and cold, and you sneezed. So the nasal fluids will also get contaminated in the body fluids which are at the scene of crime. So inevitably, you were not at the scene of crime for perpetuating that crime, for committing that crime. But during the investigation, it will be found that yes, there is one more DNA of some person. Now that person is you. So you're in a contaminated thing, and that is why you might have seen, we wear body protectors, like put up a mask, put up a glove. Why? When initially I joined, I was wondering, what is the importance of wearing gloves, and why are they wearing mask? Are they feeling that they might get infected? Then ultimately during the study I realized, oh, they wear masks so that they don't leave their traces. They wear gloves so that they don't leave their fingerprints there. So that is the integrity of the scene of crime. You should not leave anything there, because Locard's principal exchange does not distinguish between an investigator and a perpetrator or a victim. So this is one of the biggest limitations of contamination. Now I will give you a very good example of contamination of case subsequently. Next, there are what are the types of forensic evidences that can be collected. Next, so now I have divided evidences into two, three parts. Number one, the physical evidences. What could be the physical evidence? The physical evidence could be a weapon, it could be a clothing, it could be various trace materials. Now, these physical evidences are tangible. You can touch them, you can feel them. That is why I give them a platform of physical evidences. Now, let us see what are the other types of evidences. Next, the biological evidences, blood, saliva, hair tissue, all these body fluids, these are biological evidences. Next, then we have chemical evidences. Now, if you see the cases of NDPS, the drugs, the toxins, the explosives, all these things will have to be evaluated from the chemical point of view. And that is why we call it chemical evidences. Like, drugs, what NDPS is. Right now, there are so many drugs which are artificial, which are synthetic ones. Now, chemical analysis will only be able to tell you all those things. Now, toxin, what type of a toxin is that? Whether it is a pesticide, whether it is a rat poison, or what type of poison is that. Then the other evidences would be the digital evidences. Then what are the things that come in digital evidences? It is the mobile phone, computer, CCTV, all the digital media. Next, then we have documentary evidences. What type of documentary evidences will you be getting in a case? It could be handwriting, it could be signature, it could be a possible document. Now, with regard to documents, I would like to impress upon all of you here that when you write something, or you are putting your signature on the paper, you are leaving your fingerprints on the paper. And to tell you, for the benefit of the law students, at the time of when you are trying to have an investigation, then I would like to ask you a question, that from the paper, till how many days during any investigation fingerprints have been lifted? It will be very difficult for you to comprehend the number of years. To tell you, in the recorded history, fingerprints from a document have been lifted even after 80 years. 80. So, in normal parlance, what will happening? Oh, it is a very old paper now, we can't extract fingerprints from it. In recorded history, it is 80 years. Even after 80 years, fingerprints have been lifted from a paper. So, then again, that Locard's principle of exchange. You are writing something, you are giving your signature. So, you are leaving your fingerprints on the paper. There is exchange of information between the paper and yourself. So these documents, if it has to prove whether this person signed that or not, especially in document related cases, this can be a very good piece of evidence. There is a technology called ninhydrin technology. Through ninhydrin technology, the fingerprints are lifted from the documents, and then you can prove, like in forged will cases, this particular thing can be a major forensic input. that Dadaji had given us this property, but the date of the Dadaji's death and the signing is not matching because the fingerprints on the document are someone else. So in documentary cases, the fingerprints will play a major role. Next, then types of forensic evidence, physiological or psychophysiological evidence. I have done my PhD in forensic psychology. In psychology, what we do, I will give you an example. Like when you are investigating any case right now, you take up any case, there would be some interface of computers. So what would be the thing? Everyone would run after the hard disk or the mobile phone or the computer and extract information from there. But I'm trying to address the investigation, the crime from a different perspective. I'm saying that in every case you are running after the hard disk of any goddamn thing, any digital media. But you're not targeting the original hard disk. This is the original hard disk. Everything emanates from here. So what we should do? There should be a check above the neck. Apart from the digital media, apart from the hard disk that you are trying to locate, you must also check this evidence. So, what is the evidence here? It is these physiological or psychological evidences. Now, I will come into the forensic psychology part. Next. So, what these are things, what can help you? It can help you in detecting deception, the recognition of stimuli, or the cognitive states of a person. Now, these are all intangible. You cannot see them, you cannot feel them, and that is why we call it psychophysiological evidences. Now I will another give you examples of these, how to give in detail about that. Next slide please. Yeah, so evidence derived from measuring of an individual's sign and symptoms like physiological or neurological responses. Next next. So, what are these physio and psychological evidences? Uh, uh, I think you have skipped one. थोड़ा पहले जाइए. हाँ, yeah. Now, what are these physio psychological evidences? They are brain activity, the heart rate, the respiration. Like when you interrogate a person, I'm sure if you touch his heart, and if he's a really criminal, you will be feeling the pounding of the heart. That when I asked this question, his heart started pounding. Now that is a physiological response to your question. Or maybe he will start panting. So these are the physiological and psychological evidences which can extract from the point of view of forensic psychology. Next. Now, from the skin, what can you get? The skin conductivity. From the eyes, you get the eye movements. Voice that. I would be giving an example of the new technologies which have come, which are measuring all these things. But again, these things are not tangible. They are all intangible. You can just see it. Now, this is the area in which I have devoted I would say I have devoted my 20, 25 years in the forensic psychology. And I have used it in almost all the cases with startling results. Not only small cases, but up to the case of terrorism. So these psychophysiological evidences have played a major role in my investigations. And I'm very grateful to Dr. Asha Srivastava. There is a she was the former director of the Central Forensic Science Laboratory of CBI. And when I was in CBI, she was the person who used to look after the forensic psychology. And together, we developed the art of, crime scene profiling and criminal profiling. And in very many cases, we began it with the case of Bhavri Devi case, in which the criminal profiling was done for the first time. So, these are the psychophysiological evidences which need to be taken into consideration while investigating the cases. Next. Now, these methods rely on the assumption that deceptive behavior or recognition of crime related information produces measurable physiological changes. Like, If someone is speaking lies, you get a gut feeling कि ये झूठ बोल रहा है. Don't you get that gut feeling? You get a gut feeling because you are monitoring the psychophysiological changes. Like, he's fumbling, or maybe he started perspiring. So you come to know that yes, he is lying. Now, these are all our forensic evidences from the forensic psychology. Next. So these physiopsychological forensic evidences are typically investigative for screening suspects, elicit confessions, and narrow down leads. Suppose you have 20 people. Now, for interrogating 20 people, it will take hell of a lot of time. So, if you are trained into this aspect of physio-psychological analysis of the person, you will be able to tell, out of these 20, I think we must focus on these five because they seem to be very perplexed. Their body movement is different, and there are certain people who are relaxed, who have got to do with this crime. But there are certain people who are very very they're conscious about it, and then you can make out. Now these are the psychological changes that can help you in understanding the psychology of a person. Next. Then there can be, though they're admissible. Now the whole question is, when I teach forensic psychology, various types of evidences that we are gathering in the investigation, are they admissible in the court of law? To tell you honestly, I will be talking about the various other psychological evidences. I'm just telling you that all these psychological tests, and that has been like from polygraph, brain fingerprint, narcolepsy, DSLVA, eye detector, and so forth. They have absolutely no evidentiary value, and they are simply called scientific aids to investigation. AIDS in capitals. It is a scientific aid. Now, in conjunction with other evidences, you make it potent enough. So, this is the art of when you're trying to get a confession. Now you're getting to know, yeah, ये झूठ बोल रहा है. So let's go in for scientific investigation. Let's put him on polygraph. And if the polygraph results are corroborating your gut feeling, it means you're on the right track. And then, for did you go for narco analysis, you go in for bin fingerprinting. So at the end of all these psychological evidence, you can prove that yes, there is a circumstantial evidence against this person. And suppose during the investigation you get a fingerprint or you get a blood report there, then your case is done. But their reliability again depends upon how well it has been done. And scientific validity, there is scientific validity, but from the point of view of evidence, it depends upon the honorable judge how much he appreciates and how much the prosecution has been able to convince, and how has the defense taken into consideration. Now subsequently I will be discussing various cases in which how we will see how the prosecution and how the defense have taken up that case for appreciation of evidence. Next. So what are the key forensic disciplines? Next. Forensic biology, DNA, body fluids, tissues. Now we are coming to DNA part. Next. Then forensic chemistry, drugs, poisons, explosives. Next. These are the key ones. Then forensic ballistics, firearms and ammunition. Next. Then alcohol, narcotics, toxins, again chemistry part. Next, forensic toxicology part. Then digital forensics, cybercrime investigation. Now these are the most important ones which I would like to focus. Apart from them, there are others also important ones, but these are the most important ones. Next. So DNA evidence. Now let us come to DNA evidence. The appreciation of DNA evidence in the court of law by the prosecution, by the defense. Now it is a gold standard of forensic evidence. It establishes identity with high accuracy. So I will give an example. In 2004, I was additional commissioner of police, Ahmedabad city, and a gang rape took place. And during that case, after 7 8 days, the victim, she committed suicide, and the case was blown. It hit the headlines all over, and it was a very very different type of case. So that case, finally, I took over myself and I supervised the case. And in that case, for the first time during investigation, I said I will be going in for DNA fingerprinting. Now the opinions were divided. What's the point of doing DNA fingerprinting in a rape case? Because DNA is generally for paternity test. Now, that application from paternity to sexual assault cases, that migration took place. And in that case, when we went in for DNA fingerprinting, we were able to prove that yes, these are the people who had committed this this act. And you will be happy to know that based on the DNA report, all the seven people were given life imprisonment. Now, this is the value of forensic evidences and how you are putting it up, how you are weaving the entire case, how you are weakening the defense arguments, and you are strengthening the prosecution part. Next. It is used in paternity disputes, criminal cases, disaster victim identification. Recently, you might have heard about, and you might have seen the major Air India crash in Ahmedabad. For that disaster victim identification, DNA has played a major role. One of the most important issues that came up in that investigation, that the small babies, the small children, they had totally been burned. Now, how do you identify them? There's hardly any material left for extraction of DNA. Now, for this disaster victim identification, I have used it in a case of West Bengal in which 149 people died when two trains collided with each other. So DNA helped us in identifying who are the people who are dead. So DNA plays a major role for identification part, and this is the gold standard so far. Next. Then, but the worst problem with DNA evidence is that it requires hell of a lot of scrutiny for collection, preservation, and interpretation. Subsequently, I will be discussing about a case in which these all things came to the rescue or to the dismay of the prosecution. Now let's come to the fingerprint analysis. Next. So it is the oldest and most widely used forensic tool. I would like to focus on fingerprints because it is unique to authentication. And I would also like to inform the people out here that from fingerprints, we can also extract DNA. So if you are leaving your fingerprint, you are also leaving your DNA at the scene of crime. So I would like to combine not only if I want to establish the thing that this person was in that room. So I would go in for fingerprint analysis plus I would go in for DNA fingerprinting also so that it is foolproof. There cannot be any iota of doubt if we have two evidences with us. There's fingerprint and the DNA of that person. Next. So useful for linking suspects to crime scenes. You are leaving again that Locard's principle of exchange. You are entering a scene of crime. You are leaving your fingerprints there. You are leaving your body fluids there. Next. Then fingerprint requires expert interpretation for reliability. Because I have seen in this Bijal Joshi gang rape case, which I investigated and got conviction, they hired a private forensic fingerprint expert, and he said, no, the handwriting is different, this is not that. So you have to face all these confrontations. So it requires a very very expert handling so that you can prove that yes, there is no iota of doubt with regard to its prosecution. Next. Now, digital evidences. I need not explain anything about digital evidence because I have already told you about the Locard's principle of exchange in this, and that is how you capture all the evidence and connect the various people. Next. Then increasingly significant in modern crimes. Digital fingerprints are left everywhere, digital footprints are left everywhere. And we have number of softwares through which we can extract all these things and then produce before the honorable court. Next. Then digital evidence includes emails, chats, browsing history, GPS data. Next. So it must, but again, like DNA, in digital evidences also, there has to be a proper procedure for seizure and analysis. So ultimately, at the end of the presentation, you will realize it is the procedure which is more important. The technology is very important, but the procedure in the manner, the seizure, the analysis, these all play a major role in gathering of evidences, especially during the trial. Next. Then digital administration is governed by IT Act and BNSS Evidence Act in India. Next. Importance of chain of custody. Now, I was trying to, I was reading most of the judgments, and I used to find that this particular thing, chain of custody, that was the most important problem facing all the investigations. And the cases were going in for acquittal only on account of chain of custody. Now, let us see what exactly is chain of custody and what do we mean by chain of custody. I should tell you, very many police officers, they have not much enough idea about chain of custody, and as a result of that they do the investigation, but at the time of trial there is a broken chain of custody. Now I have cited some of the examples which came into the fore after for preparing this presentation in the live cases. Next, I will be discussing that subsequently. Next. Now, this documentation of chain of custody, you pick up evidence, you store it. Now if you see this diagram, the chain that holds it all together, number one, siege and label, then track every handler, store it at a safe place, then document every detail, and finally present in the court. So one broken link in this entire chain, the evidence will fall apart. And with my experience, I can tell you, you just read any of the acquittal judgments, you will find that the biggest enemy is the chain of custody. And it is a very favorite friend of the defense people. They would always target the chain of custody. Next. So what the defense would ask? They would ask you, please give us the detailed records of transfer from the scene of crime up to the court, showing each and every transfer of the evidence. And I'm sure there can be so many mishaps in between that you might have fallen. Now let's see what are the problems that have been seen in this. Next. So transfer evidence from the crime scene to the lab. That is one part, one chain. Next. Next. Then eventuality to the court. The entire event has to be recorded somewhere. There should be no breakage. And this is the bane of all the investigations. Next. So there may be missing signature. The inspector might have forgotten to sign on the panchnama. Now that is a breakage of chain. And as a defense, I only look for all these things. What are the inconsistencies? There may be incomplete form. You might have forgotten one caption to be written there. There would be missing signatures. Next, please. There could be incomplete form. You have not filled the entire detail. It is incomplete. Next. Then the date, address, time. There could be discrepancy in date, time, and address. Maybe there are two things colliding at the same time. At the same time, you are showing that you are at the scene of crime, and your diary is showing that you were doing night patrolling, because everything is documented. So all these things will be taken care of by the defense people. They will target only this thing. Next. Then let us come at the scene of crime now. Next. So, no, this is the importance of chain of custody. We have to ensure the integrity of the entire chain, integrity of the evidence. Only then the honorable judge will give value to the evidences which are putting forth. Next. Then it prevents, what is the importance? It prevents tampering of contamination. Now, you will be happy to know that in Gujarat Forensic Science Laboratory, everything is blockchain now. Each and every activity is on the blockchain. There is absolutely no reason that you can possibly tamper. There is absolutely no reason that you can enter it and make some addendum. I remember one case in UP in which the FSL director of UP, he was arrested because he tampered with the evidences. The FSL director. That is reported in the newspapers also. Next. Then it documents every transfer of evidence. Whatever has taken place, it is recorded there. Next, then it is critical for admissibility in court because the defense is going to target only this particular thing and they will like to find out if there is any breakage in the chain of custody or not. Next, then breaks in chain will certainly weaken the case. One missing signature, everything is perfect, but one missing signature will be caught hold of by the defense people and they will say, my lord, this is tampering of evidence and we don't, there is no integrity of the evidence. Next, then role of lawyers in forensic evidence. How we can play a major role in this. Next, number one, the understanding of scientific report and the expert opinions. If you have not read any DNA report or any document reporting or any digital evidence report, how are you going to ask any question? How are you going to understand it? So you'll have to read the reports. I can assure you that in I have seen that in even in police, sir, वो report आ गया, sir, the report has come. What does it say? Sir, the DNA matches, or sir, the fingerprint matches. Oh, very good. Let's archive the case. You will never go through the entire report. There may be some inconsistency in the report. And I can tell you that, अब CBI में तो we had to, do the dissection of very, very minute things. I have found that not many people used to read the forensic report. And from those forensic reports, we used to call out things. Yes, this is a lacuna. We must plug this thing. Next, next. So while cross-examining, if you have no idea, if you have no idea about the reports, you have never seen any report, how you are going to cross-examine the people there? So, the lookout principle of exchange, the chain of custody, and all these things will have to be taken in account while cross-examining the person. Next, then ensuring the admissibility by verifying the chain of custody. You will also have to verify whether the chain of custody is complete or not. And if it is incomplete, then you have to make it up for that as a prosecution. And you also will have to make it up as a defense. So the chain of custody is of vital importance in all the cases wherein the forensic reports are there. Next, next. So using forensic findings strategically in arguments. You will have to know all this. Only then you can use them. Next, then limitations and challenges. Next, delays in forensic report. Right now the forensic labs are so burdened with so many cases that if you are able to get a report in 1 month's time, you should be very, very lucky. I know there are cases in which 3 4 years have taken. Now that is a very, very it's a shot in the arm of the investigation. Now suppose the DNA report doesn't come in and the person has applied for a regular bail. So what do? You don't have the DNA report. That will go in favor of the accused, and the court might enlarge him on bail. So now, what is the problem? There is limited forensic infrastructure in the country. Then these are one of the biggest problems with us. But gradually, I am very happy that the new BNSS Act has come, which has made that in every case in which punishment is more than 7 years, forensic interface is mandatory. So as a result of that, the government is pumping lots of money in creation of the infrastructure. I think in 5 years we will be having a very good forensic infrastructure. Now, when we are talking about forensic infrastructure, I would also like to talk about the quality. Now, for quality, again, the defense would raise the issue of NABL accreditation, whether your lab is accredited or not. I would also like to tell the officers here that today I was with the Quality Council of India, who are doing the NABL, and I had a very good meeting with them. That how to make now, since I am advisor to government of Assam and my duty is to capacity building for forensics, so I have taken about myself that my facility in Assam will be NABL accredited, and you will be surprised to know that none of the labs in all the 7 sister states, including Assam, they have no NABL accreditation. Now what about the standardization? What about the ethics? What about the integrity? All these things. Now, if I am a lawyer, I would say, well, since this lab is not accredited through NABL, Sir, the evidences, I doubt that it is of standard quality. I doubt, sir. And what is the role of defense? The role of defense is to raise doubts, and that is why he gets a fat fees. So these are the things that are coming in the way, but gradually things will improve, I believe. Next, so misinterpretation of scientific findings. The defense will always like to pick holes. Like in that Bijal Joshi gang rape case, they said, "Sir, the handwriting doesn't match," but the government handwriting experts say it fully matches. So they will try to misinterpret and give a different picture to it. Something new they will extract. And this will no, 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 this evidence is not. That is why, if you are not reading the reports, if you do not know the nitty-gritty of forensic science, how are you going to confront them? So, reading of forensic reports, understanding forensics, logarithms of exchange is very, very essential not only for prosecution but also for the defense. Next. Then possibility of contamination or human error. Like in one of the rape cases, it was found that the two cases were being examined simultaneously, and the reports got exchanged. Now this is a human error. It can also be a contamination. Next. Next, please. So I will narrate a very good example. I would like each and every one of you to read about the Phantom of Hilbron. It's a very interesting case. Kindly note down Phantom of Hilbron. Kindly read it in great detail to understand what exactly is contamination. So I'll tell you in nutshell. Please slides go fast like because it's already 8 and I have number of slides more to go. But I would like to whenever you tell me to stop, I will stop. But I would like to tell you about this, the Phantom of Hilbron. It's a recorded thing. You can just Google it and you will know. Next. So it was a faceless killer and the unmasking of mystery of the Phantom of Hilbron. Several murders took place across Europe with the same DNA at all the places. Now it was a mystery. How can one person commit so many murders in various parts in the entire Europe? Next. So the story. Next, please. Next, please. So this is the Phantom of Hilbron, woman without a face. Now there was a serial killer. She used to kill. She used to she used to do the mugging, the burgle, and all sorts of activities was being done by by this lady, some mysterious lady. Next, the killer is known only from DNA evidence. So all those scenes of crime where all these things had taken place, they analyzed and they found that at all the places there is one common DNA, and that common DNA is this profile. But who is this lady? Who is sprawling all over the places and doing this case? So DNA evidence was present at different 40 crime scenes in Austria, France, and Germany. Next, the crimes were committed or happened between 1993 and 2009, 40 years. Next, police spent 16,000 hours of overtime. Euro so much was given as reward. Ki please find out who is this lady. Next, so, six murders, it includes six murders. But ultimately, it was a police officer Michel Kieswetter in Hilbron, in Germany. He was murdered on 25th of April 2007. What happened? Then 2000 March interrogations concluded that there was no phantom. Please, next. There was no phantom criminal. Actually, what was to happen? That the swab which was manufactured in a company that was taken by the various countries. And that swab through which the DNA extraction was done, that was contaminated with the DNA of this lady. And that is how this contamination was, found at all the places. Now you can imagine the contamination. This is a very good example of how contamination can mar your cases. So finally, it was found that she was an innocent woman working in a cotton factory which used to manufacture swabs. Next, next. So this is the Phantom of Hildron. Kindly go through it. Now, now what are the limitations and need for continuous legal and scientific training? That is very important. Next, use of now I was just I keep reading about forensics. So about how to train the honorable judges. So the University of Dundee in UK, and there is a very good research center called Liverham Research Center for Forensic Science. This is all available. You can go to the website also, University of Dundee. So, they made a study, the role of science, forensic science, comics in forensic evidence communication. New word, forensic evidence communication. Communicating forensic science in courtrooms. The judges are not trained into forensics. They're not DNA experts. So how you communicate with them? The art of trial, the art of communication. So they used comics. Forensic, yeah, please, next, please. Forensic science plays a crucial role in criminal trials. Expert maintenance help jurors make informed decisions, and clear communication is essential. Now, how did they come to the communication part? Next, I think we must expedite this because the nutshell is that they explained forensic concepts through comics to the honorable judges, and then they made a study. Before seeing the comic, what was the interpretation of the honorable judges, and after seeing the comic, what was the interpretation of the judges? And it came to be known that after seeing the comics, the judicial appreciation enhanced. So, next slide, please. Now, Dr. Kulpesh, I have time. If you want to continue, I am ready to continue. But I would leave it to Dr. Kulpesh.
So maybe in 10 minutes,
Okay.
in some
Then what I
cases
would
we can
say,
go.
yeah, yeah. Kindly complete this communication part. Kindly finish that completion and come to the next slide. Just keep rushing. Just keep rushing. Just keep rushing. Just keep rushing. You complete this part because I have given you the nutshell how comics have played a role in communicating the judges and appreciation of evidences. Next, 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 please. Next, next. Please, please, please. Please, please, please. Please, please. Next, next. Please, please go ahead. Go ahead. Please go. Please. 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 Please go ahead. Please go ahead. Please, please. This is all about comics, how they have played a role. Next, please. Next. 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 This is a very interesting find. I thought I must explain to the people with regard to the forensic communication. Next. 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 So thank you for watching Science Comic Research. We come to the next. Now, case study. There are some live cases that I have discussed here. Now, rape murder, Supreme Court acquits. This is 8th April 2025, just recently. Supreme Court acquits by the acquits. Supreme Court acquits. Now let us see what exactly why acquittal took place when the High Court had already convicted. Next. Death penalty in child rape murder case set aside. Supreme Court flags illegal admission of confessions, lapses in DNA evidences. Next. The Supreme Court allowed criminal appeals. This is the case. Sanjay Karol J, Vikram Nath, Sandeep, they had acquitted the case. Now I have tried to study why it was acquitted. Now there were 5 acquittals in this year. Number 1, Mid Bani Alam Mazid, Vinod Kumar, NCTD, on all these 5 cases have been acquitted. Now let us see why it was acquitted. What went wrong in these cases? Next. Next. So, I have understood. Kindly go through this. There are 5 judgments. If you see the last reason for acquittals, faulty chain of circumstantial evidences. Statements contained omissions, then suspicious extrajudicial discrepancies and omissions. Last in theory, not trustworthy. Next, in all these cases. Next, Karnataka man spends 1.5 years in jail for wife's murder, and the wife walks into the court alive. What type of investigation was committed? Have we gone in for DNA? Have we done it with investigation? The person would have been out. 1.5 years that person spent. This is the person accused her being in jail for 1.5 years because the identification was not done properly, and he was forced to accept, yes, this is indeed his wife. He was forced, and that is why he got. So the DNA played a major role. Now in Uttarakhand case also, this is again, yeah. Next, please. The Karandeep Sharma. You can kindly go through these judgments and read the judgments. Background of the case. Next. Next, please. Next, please. Yeah, victim was a minor girl. FI. Previous. Yeah, previous. Yeah, victim was a minor girl aged approximately 7 years. And incident took place during a Jagran. She was raped and she was murdered. Next. FIR was filed with father. Allegation of sexual assault. POXO case. Next. And rape. Next. The key linking evidences and the Supreme Court reversed the judgment. Now, what went wrong? Next. Trial court, fast track court, special judges, they all convicted. High court, all convicted. Supreme Court, bench, they acquitted. What went wrong in this? Next. Key evidences presented, last in theory, post-mortem, DNA FSL report, confessions, etc. But despite all these things, the case could not get into conviction. Next. Entire case based on circumstance. The court says entire case is based on circumstance evidence, no direct link to the crime. Again, Locard's principle of exchange. Why it was not linked properly? Next. Then DNA expert not examined. Confession allegedly under duress. Next. So, proper forensic chain of evidence, ideal protocol, which is not done in this case. Proper collection with sterile, immediate sealing and labeling, documented chain of custody, storage in controlled conditions. All these things were not followed. Next. So, forensic chain of ideal protocol to legally admit DNA evidence, timely transmission, expert testimony, and ensuring tamper-proof integrity. Next. So, what was done in this case? Sample collected. All these things were collected. They were collected by the medical officer, sealed, not clearly documented. Next. Chain of custody, broken, undocumented. DNA expert, no examination in court, submitted by investigating officer instead. Imagine, so much of laxity. Next. Then DNA report cannot be read in evidence without examining the expert. The expert was not examined. Next. So no witnesses from FSL confirmed sealed receipt. Imagine small things. Next. No test identification period taken. Confession not voluntary and not relied upon. Witnesses failed to identify. Last theory was questionable. Next. Samples may have been tampered. No proof of sealed transmission. No Malkhana entry or forwarding memos. Again, that chain of custody, chain of command, following the procedure, the protocols. Next. Issues in collection and handling. No written record of sealing. No signed handover receipt from hospital. Next. These are collection lapses. Then handling issues. Samples moved without logs. Confusion over who carried what. Constable Vijay Pal, key link individual, he was not examined. Next. So no storage logs or preservation timeline. Not proven if samples degraded or exposed. These storage gaps. Next. So legal mandates were ignored. Next. So, I think the entire in this chain of custody was unreliable. This was the observation of the Supreme Court. DNA never explained or authenticated. Next. Result, appellant acquitted. Next. Now, these are some of the critical quotes from the judgment. I think I must finish off here now. If you want, I can continue, but I leave it to you. I don't know how many slides are still remaining. I think we have reached. Next. 176.3. आप रन कर दीजिए, जो इंपॉर्टेंट होगा आई विल आस्क यू टू स्टॉप. Next. Yeah, with the coming of National Forensic Science University, this is getting a fillip now. Next. Nirbhaya judgment, kindly go through it. Collaboration between legal and forensic experts is vital. Next. Now this is my, just see if you can run this Jolly LLB clip. We will end by this. क्लिप को चलाइए, बहुत मजा आएगा. नहीं चल रहा है? हाँ, उस पे
Yes, sir.
क्लिक कीजिए.
Sir, yeah, what?
नीचे जाइए, नीचे.
Yes, sir. मैं
हाँ.
audible?
Sound is not there. तो I will conclude by this. इसमें क्या है? Ultimately, the judge tells कि केस के शुरुआत में मेरे को पता होता है. केस के शुरुआत में मेरे को पता होता है कि मुलजिम कौन है. लेकिन भाई मैं तो जज हूं, मैं कैसे जजमेंट दे सकता हूं? मैं वेट करता हूं कि अब एविडेंस आएगा. एविडेंस आता नहीं और गट्ठर के गट्ठर पेपर चले जाते हैं. अल्टीमेटली को छोड़ना पड़ता है. तो बाय दिस क्लिप आई वांट टू प्रूव दैट गेटिंग कन्विक्शन इज इन योर हैंड. आप अगर अच्छा इन्वेस्टिगेशन करके जज साहब को दोगे तो जरूर कन्विक्शन करेंगे. अभी आप देखिए कैसे रेप केसेस में कितनी लैक्सिटी है. so much of laxity in that. So, I would like to conclude now. And thank you so much. I really enjoyed all these things. But I wish it was an offline session. We would have entered into so many questions. So I conclude my presentation here. I have taken 15 minutes more.
Thank you, Dr. Kumar, for that enlightening presentation on forensic evidence and its analysis. We now open the floor for questions. Participants, please use the raise hand feature or type your questions in the chat box. Dr. Sir will address your queries about forensic evidences, DNA analysis, technology integration, and any other
Yeah,
topic.
we'll take up only one question from Jay Sharma and then we'll close.
Okay.
Yes.
Yeah, can I ask that question?
Yes.
Yeah,
Please
please.
introduce yourself and then ask. Yeah.
Okay, sir, I am Ajay Sharma, advocate, and I deal with the electronic evidences. So one of the problem which we are facing is that, in case of electronic evidence, since the examiner of electronic evidence labs are very limited, only 16, 17 labs are approved. So can we use the private labs for the, as an authentic evidence? One, two, in the section 63 for C certificate, part B, where the expert has to, certify who can be the expert, which is actually not very clearly visible in the Bharatiya Sakshya Adhiniyam. These two questions, sir.
Yeah, actually, with regard to digital evidences, things are very, very different, and not many forensic labs are there which can possibly get, apart from the government labs which are there. So with the so much of load on forensic labs, I am told that even the Honorable Home Minister has mentioned that they are going to give accreditation to the private labs also. So till the time we get accreditation from the private lab, so that we are able to get quick reports, I think we'll have to do the way we are doing it right now. But again, I would tell Even if you have a report which is not from a government source, but if you are able to convince the court that the entire chain of custody, the entire protocol, each and everything that is mandated has been covered in this, now that depends upon your arguments in the court. If you are able to convince that yes, I have done all the things, again, even if everything is followed by the investigating officer, in very many cases the court doesn't accept it. Like you take the example of this DNA case in that cases. The investigation officer went to the forensic lab. They got all the reports from there. But despite that, it did not reach the stage of conviction. So I think only two things. Number one, the chain of custody and the protocols. If we are able to convince the court, yes, we did not have any forensic expert, but this is what we have in our hand. And if you can convince the court, I think the court will obviously accept. But unfortunately, the issue is the appreciation of evidences, let alone conventional crime. But in the cyber issues, it is very difficult because even the judges are not very sure about all these things. So
Okay.
I think this will
And who
certainly
can be the
pursue.
expert, sir? Who can be the expert as per the part B of the?
Actually, to tell you very honestly, with my experience, I would like to narrate instance to you. Like when we were ASPs, Assistant Superintendent of Police, so we used to investigate वो चोरी का केस होता था, and the ornaments were seized, and finally they used to melt that ornament, and they used to make blocks. So when we used to get all these things recovered from the person, we used to go to the local jeweler. Now the
Mhm.
local jeweler will tell you, yes, it is gold. Now you please tell me where in CRPC or in the BNSS Act it is mentioned that jeweler is an expert.
Mhm.
I think it is upon the court to whom he consider that he is an expert. So till the time when all the labs are accredited, which I think will be very difficult. So we must focus on the integrity of evidence, the chain of custody. Then I think we'll be able to convince the honorable judge. Till then, we'll have to make do with this. I have no particular answer, but this is what I feel, because whenever I investigate, because there were so many cases in which we were not getting experts. Like, well, I will give an example. In Goa, there was a case in which 25 kgs of marijuana were missing from the Malkhana of police station, and some internal investigation took place, and there was some, yeah, they mentioned that 25 kgs of marijuana has been eaten away by white ants. And then the High Court took objections to it. Like, how can white ants eat the marijuana? So finally, the case was shifted to CBI. I was joint director CBI Mumbai, and the case came to me. So I said it is very open and shut case here. If I am able to prove that white ants cannot eat marijuana. Now, where in the world there is any research whether white ants can eat marijuana or not? No, there is no evidence. There is no research. So finally I caught hold of an institute in Calcutta, the Entomological Institute of India. So I asked the director, "Ki, bhai, please tell me, can white ants eat marijuana?" He said, "No, they cannot eat." Now, do you think the entomologist is mentioned in any of the document that he's an expert? He is an expert because of his experience, because of the post that he's holding, because of the work he's doing. So, I mean, this is what is my answer to you right now. I cannot possibly give any answer to it, but yes, if you are able to prove it chain of custody, if you are able to
Right.
prove integrity of the, I think the court should accept it. I
Thank you
mean,
so
this is,
much, participants. Yeah.
I hope to convince Mr. Ajay. I think he has quit.
No,
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 I'm there,
sir.
sir. I'm
Yes,
there,
sir.
sir.
Yes. Yeah,
So
yes,
yes,
sir.
sir. So as per the BSA, there is a section 39(1), where the expert is defined. So I think since it is not very clear in the section 63, but I think we as a lawyer we can use the section 39(1) to bring the kind of entomology example you gave, or the other examples of the jeweler, that one who is
Very,
expert in their own area with skill can be proven as an expert. Yeah. Thank you,
upon
sir.
you
Thank
to
you.
actually the entire investigation is nothing but convincing the court. आप
Correct, sir.
कैसे convince?
Mhm.
And that is the art of argument, and that is the art the lawyer has.
Correct, sir. Thank you.
Thanks.
Thank you once again, Keshav sir, for sharing your invaluable expertise and practical insights with us today. Your extensive experience in forensic investigation and the interaction of technology with criminal justice has provided us with deeper understanding of this critical field. The examples you have quoted, the practical things which you have quoted, the case laws, the case studies, the all the real-time experience that you have experienced, that you have shared with us. That is phenomenal, sir. And this concludes today's session of our 15-day capacity building program. We look forward to seeing you in our upcoming sessions, definitely, sir. And have a wonderful evening, everyone. Thank you so much once again, sir. Thank you, thank you, thank you so much.
Thank you. Thank
Kindly
you.
send me the questions
Yes, sir. Yes, yes.
and kindly follow me on my LinkedIn. I keep writing so many things on
Sir,
LinkedIn.
we would love to follow you on LinkedIn. We will not let you go like this.
Yes. Perfect. Thanks.
Thank you so much, sir. Namaskar, sir.
For bearing with a police wala for such a long time. Thank you.
Good evening. Good evening, everyone. Good